Please subscribe, like and share this content. It means a lot to us. Thank you in advance. U.C.C. Article 9. Secured Transactions. Part 5. Filing. Subpart 1. Filing Office. Contents and Effectiveness of Financing Statement. Paragraph 9501. Filing Office. A. Filing Offices. Except as otherwise provided in subsection B, if the local law of this state governs perfection of a security interest or agricultural lien, the office in which to file a financing statement to perfect the security interest or agricultural lien is 1. The office designated for the filing or recording of a record of a mortgage on the related real property, if A. The collateral is as extracted collateral or timber to be cut, or B. The financing statement is filed as a fixture, filing in the collateral as goods that are or to become fixtures, or 2. The office of, or any office duly authorized by. In all other cases, including a case in which the collateral is goods that are or are to become fixtures and the financing statement is not filed as a fixture filing. B. Filing Office for Transmitting Utilities. The office in which to file a financing statement to perfect the security interest in collateral, including fixtures, of a transmitting utility is the office of. The financing statement also constitutes a fixture filing as to the collateral indicated in the financing statement which is or is to become fixtures. Paragraph 9502. Contents of financing statement. Record of mortgage as financing statement. Time of filing financing statement. A. Sufficiency of financing statement. Subject to subsection B. A financing statement is sufficient only if it 1. Provides the name of the debtor, 2. Provides the name of the secured party or representative of the secured party, and 3. Indicates the collateral covered by the financing statement. B. Real property-related financing statements. Except as otherwise provided in Section 9501, B. To be sufficient, a financing statement that covers as extracted collateral or timber to be cut, or which is filed as a fixture, filing and covers goods that are or are to become fixtures, must satisfy subsection A and also 1. Indicate that it covers this type of collateral, 2. Indicate that it is to be filed, for record, in the real property records, 3. Provide a description of the real property to which the collateral is related, sufficient to give constructive notice of a mortgage under the law of this date if the description were contained in a record of the mortgage of the real property, and 4. If the debtor does not have an interest of record in the real property, provide the name of a record owner. C. Record of mortgage as financing statement. A record of a mortgage is effective from the date of recording as a financing statement filed as a fixture filing or as a financing statement covering as extracted collateral or timber to be cut only if 1. The record indicates the goods or accounts that it covers, 2. The goods are or are to become fixtures related to the real property described in the record, or the collateral is related to the real property described in the record and is as extracted collateral or timber to be cut. 3. The record satisfies the requirements for a financing statement in this section, but A. The record need not indicate that it is to be filed in the real property records, and B. The record sufficiently provides the name of a debtor who is an individual if it provides the individual name of the debtor or the surname and first personal name of the debtor, even if the debtor is an individual to whom Section 9503A.4 applies, and 4. The record is duly recorded. D. Filing before security agreement or attachment. A financing statement may be filed before a security agreement is made or a security interest otherwise attaches. Legislative note: language in brackets is optional. Where the state has any special recording system for real property other than the usual grant or grantee index as, for instance, a tract system or a title registration or torrent system, local adaptations of subsection B and Section 9519 D and E may be necessary. See, e.g., Mass. General Laws Chapter 106, Section 9410. A state should enact the 2010 amendments to Section 9502 only if the state enacts Alternative A of the 2010 amendments to Section 9503. Paragraph 9503. Name of debtor and secured party. A. Sufficiency of debtor's name. A financing statement sufficiently provides the name of the debtor. 1. Except as otherwise provided in paragraph 3, if the debtor is a registered organization, or the collateral is held in a trust that is a registered organization, only if the financing statement provides the name that is stated to be the registered organization's name on the public organic record of most recently filed with or issued or enacted by the registered organization's jurisdiction of organization, which purports to state, amend, or restate the registered organization's name. 2. Subject to subsection F, if the collateral is being administered by the personal representative of a decedent, only if the financing statement provides, as the name of the debtor, the name of the decedent and, in a separate part of the financing statement, indicates that the collateral is being administered by a personal representative. 3. If the collateral is held in a trust that is not a registered organization, only if the financing statement, A, provides, as the name of the debtor, I, if the organic record of the trust specifies a name for the trust, the name specified, or 2. If the organic record of the trust does not specify a name for the trust, the name of the settlor or testator, and B. in a separate part of the financing statement. I, if the name is provided in accordance with subparagraph A, I, indicates that the collateral is held in a trust, or 2. If the name is provided in accordance with subparagraph A, 2, provides additional information sufficient to distinguish the trust from other trusts having one or more of the same settlors or the same testator and indicates that the collateral is held in a trust, unless the additional information so indicates. Alternative A. 4. Subject to subsection G, if the debtor is an individual to whom the state has issued a driver's license that has not expired, only if the financing statement provides the name of the individual which is indicated on the driver's license. 5. If the debtor is an individual to whom paragraph 4 does not apply, only if the financing statement provides the individual name of the debtor or the surname and first personal name of the debtor. And 6. In other cases, A. If the debtor has a name, only if the financing statement provides the organizational name of the debtor. And B. If the debtor does not have a name, only if it provides the names of the partners, members, associates, or other persons comprising the debtor, in a manner that each name provided would be sufficient if the person named were the debtor. B. Additional debtor-related information. A financing statement that provides the name of the debtor in accordance with subsection A is not rendered ineffective by the absence of 1. A trade name or other name of the debtor, or 2. Unless required under subsection A. 6. B. Names of partners, members, associates, or other persons comprising the debtor. Alternative B. 4. If the debtor is an individual, only if the financing statement, A, provides the individual name of the debtor, B, provides the surname and first personal name of the debtor, or C, subject to subsection G, provides the name of the individual which is indicated on a driver's license that the state has issued to the individual and which has not expired, and 5. In other cases, A, if the debtor has a name, only if the financing statement provides the organizational name of the debtor, and B, if the debtor does not have a name, only if the financing statement provides the names of the partners, members, associates, or other persons comprising the debtor, in a manner that each name provided would be sufficient if the person named were the debtor. End of alternatives. B. Additional debtor-related information. A financing statement that provides the name of the debtor in accordance with subsection A is not rendered ineffective by the absence of 1. A trade name or other name of the debtor, or 2. Unless required under subsection A. 4. B. Names of partners, members, associates, or other persons comprising the debtor. C. Debtor's trade name insufficient. A financing statement that provides only the debtor's trade name does not sufficiently provide the name of the debtor. D. Representative capacity. Failure to indicate the representative capacity of a secured party or representative of a secured party does not affect the sufficiency of a financing statement. E. Multiple debtors and secured parties. A financing statement may provide the name of more than one debtor and the name of more than one secured party. F. Name of decedent. The name of the decedent indicated on the order appointing the personal representative of the decedent issued by the court having jurisdiction over the collateral is sufficient as the name of the decedent under subsection A2. Alternative A. G. Multiple driver's licenses. If the state has issued to an individual more than one driver's license of the kind described in subsection A4, the one that was issued most recently is the one to which subsection A4 refers. Alternative B. G. Multiple driver's licenses. If the state has issued to an individual more than one driver's license of the kind described in subsection A4C, the one that was issued most recently is the one to which subsection A4C refers. End of alternatives H. Definition. In this section, the name of the settlor or testator means 1. If the settlor is a registered organization, the name that is stated to be the settlor's name on the public organic record most recently filed with or issued or enacted by the settlor's jurisdiction of organization, which purports to state, amend, or restate the settlor's name, or 2. In other cases, the name of the settlor or testator indicated in the trust's organic record. Legislative Note 1. This act contained two alternative sets of amendments relating to the names of individual debtors. A state should enact the same alternative, A or B, for both subsections A and I of Section 9503. A state that enacts alternative A of the amendments to this section should also enact the amendments to Section 9502. 2. Both alternatives refer, in part, to the name as shown on a debtor's driver's license. The legislature should be aware that, in some states, certain characters that may be used by the state's Department of Motor Vehicles or similar agency in the name on a driver's license may not be accepted by the state's central or local U.C.C. filing offices under current regulations or internal protocols. This may occur because of technological limitations of the filing offices or merely as a result of inconsistent procedures. Similar issues may exist for field sizes as well. In these situations, perfection of a security interest granted by a debtor with such a driver's license may be impossible under Alternative A of the amendments, and the utility of Alternative B, under which the name on the driver's license is one of the names that is sufficient, may be reduced. Accordingly, the state may wish to determine if one or more of these issues exist and, if so, to make certain that such issues have been resolved. A successful resolution might be accomplished by statute, agency regulation, or technological change effectuated before or as part of the enactment of this Act. 3. Regardless of which alternative is enacted, in states in which a single agency issues driver's licenses and non-driver identification cards as an alternative to a driver's license, such that at any given time an individual may hold either a driver's license or an identification card but not both, the state should replace each use of the term driver's license with a phrase meaning driver's license or identification card but containing the analogous terms used in the enacting state. In other states, the state should replace the term driver's license with the analogous term used in the enacting state. Paragraph 9504. Indication of collateral. A financing statement sufficiently indicates the collateral that it covers if the financing statement provides 1. A description of the collateral pursuant to Section 9108, or 2. An indication that the financing statement covers all assets or all personal property. Paragraph 9505. Filing in compliance with other statutes and treaties for consignments, leases, other bailments, and other transactions. A. Use of terms other than debtor and secured party. A consignor, lessor, or other bailer of goods, A licensor, or a buyer of a payment intangible or promissory note may file a financing statement, or may comply with a statute or treaty described in Section 9(3)(11)(a), using the terms consignor, consignee, lessor, leasee, bailer, bailee, licensor, licensee, owner, registered owner, buyer, seller, or words of similar import, instead of the terms secured party and debtor. B. Effective financing statement under subsection A. This part applies to the filing of a financing statement under subsection A and, as appropriate, to compliance that is equivalent to filing a financing statement under Section 9(3)(11)(b), but the filing or compliance is not of itself a factor in determining whether the collateral secures an obligation. If it is determined for another reason that the collateral secures an obligation, a security interest held by the consignor, lessor, bailer, licensor, owner, or buyer which attaches to the collateral is perfected by the filing or compliance. Paragraph 9506. Effective errors or omissions. A. Minor errors and omissions. A financing statement substantially satisfying the requirements of this part is effective, even if it has minor errors or omissions, unless the errors or omissions make the financing statement seriously misleading. B. Financing statement seriously misleading. Except as otherwise provided in subsection C, a financing statement that fails sufficiently to provide the name of the debtor in accordance with Section 9503(a) is seriously misleading. C. Financing statement not seriously misleading. If a search of the records of the filing office under the debtor's correct name, using the filing office's standard search logic, if any, would disclose a financing statement that fails sufficiently to provide the name of the debtor in accordance with Section 9503(a), the name provided does not make the financing statement seriously misleading. D. Debtor's correct name. For purposes of Section 9508(b), the debtor's correct name in subsection C means the correct name of the new debtor.